Welcome back to the Business of Beautiful Spaces. Today, we are diving deep into the business side of interior design, and we're talking to Erica Canas, who's a lawyer based in Florida. And this is one area that's often overlooked, which is contracts and how important they are to our business. So, Erica is an attorney and interior design enthusiast who is joining us for this important conversation. She is also the founder of the ID Law Shop, where she creates best practice legal templates specifically for interior designers and architects. And her journey began when she couldn't find legal templates that were actually tailored for her clients. And so she saw a lot of outdated forms, very generic items, and resources that were not created by real lawyers. So, with 16 years of contract drafting experience under her belt, she made a decision and a mission to provide legal resources that are actually useful for interior designers. So, from contracts to intellectual property matters, which you're going to hear is super important to Erica, and I now understand why it is too. Erica's expertise is vast. She also offers full service copyright and trademark registration to protect your designs and your brand assets. And if you're looking for custom drafting services, her flat fee rates ensure you're protected without the fear of runaway legal fees. It is an important episode today as we discuss these legal protections for designers and how to structure your contracts and why having right legal documents in place can protect your business and not only that, help it thrive. So the only thing I want to preface it with is make sure that when you are dealing with your legal contracts that you are using someone who is in your area, who knows the laws of the state or the province or the country that you live in, and make sure that you're protecting yourself to the fullest. So let's dive in and talk to Erica all about contracts. Hi there, interior design lovers. Welcome back to the Business of Beautiful Spaces, the podcast where we blend design inspiration with all behind the scenes tips and tricks you need to thrive in your business. I'm your host, Laura Thornton, and with over 27 years in this interior design game and running a 7-figure design company, trust me, I've seen it all. I want to be your interior design bestie. I want to help you build the business of your dreams, make more money, and yes, ditch the stress along the way. I've been doing this for a long time, and now I'm sharing my knowledge with all of you, my fellow designers and decorators. All I ask in return is that you like, review, and follow this podcast wherever you listen, so other designers can find us and learn more too. So grab a coffee, get comfy, and let's dive into making 2025 your best business year yet. Welcome back to another episode of the Business of Beautiful Spaces. Today we're speaking with Erica. Hi, Erica. Thank you for joining me this morning.
Hi, thank you for having me. It's my pleasure to be here.
I'm like super excited to talk to you today about contracts and law and all the good things that designers who have decided to start their own business need to be thinking about. And I want to just jump right away. How did you start working specifically legally with interior designers?
Well, a few years ago, I was working for um an architect firm that had architecture, interior design, and landscape design divisions, and I started with them going over the contracts, working with the new contracts and clients and stuff like that. And I wanted to review and update the contracts. And I remember looking at the interior design contract itself and having several questions about it and asking the interior designers themselves, hey, what does this mean here? And how do this usually go about? How is this billing? And getting the response, one designer said to me, well, whatever's supposed to be standard, that's what it should say. So I realized quickly they didn't quite understand their own contracts. And when I was looking for resources, I couldn't find many. That's what gave me the idea to start the ID Law Shop, which is essentially a one-stop shop for all your contract templates. And I just wanted to come up with a set of best practices, uh, language for these types of contracts that interior designers need. So I scoured the internet, I read a bunch of case law, I put in all my experience of working with contracts and intellectual property and contracts and all different kinds of contracts, and created these best practices, which I've been using and selling for about 2 years now.
So these contracts would really be great for someone who's just starting out, possibly doesn't have a process in place, and doesn't actually know where their design business is going to take them. And why I'm going to keep going. I'm going to clarify that only because, I constantly say you really should work with a lawyer with your process so that you're fully protected. So like I've been doing this 27 years. I know my process. I would take it further with you and engage in getting more specific so it actually protects my business in all elements.
Mhm.
But if somebody who's just starting out or doesn't know, or the business is still ever changing, it's really great that you would have everything itemized, best practices to cover even things they probably don't even realize they need to be covered for. So, where would you say is the most common mistake you see interior designers making? I'm gonna go on a limb and say it's not have a contract, but let's say they do. What are they missing?
Absolutely. Yeah. Well, the first one is going about not having a contract or trying to rely on oral agreements. There's all a host of problems with that, as you can imagine. People's memories falter, um, different understandings, misinterpretations of what was said. So it's and also potentially not enforceable if it's not in writing. So let's say you do have a contract in place. I would say the biggest mistake is not understanding your own contract, not
Mhm.
reviewing it, not going line by line, making sure that you know what you're saying and you can explain it to your client. At the end of the day, a contract is not just there to protect you legally, but also to explain to both parties this is how our relationship is going to be governed. And it's a really good way of nipping miscommunications in the bud. If someone forgets or if something wasn't talked about, you can always go back to your contract and say, okay, that's how that works. And this is how I need to pay. And this is how many days I have, or this is what the licensing rules are going to be for this. Or if I need to do a change order, here's how I do it. Um, so the biggest mistake is really not fully understanding your contract and also not covering everything that needs to be included. I know that you cannot anticipate every contingency under the sky, but you can, in your experience, or even if you're new, um, at least with a template that's made it specifically for interior designers, include a lot of these contingencies. And so I would say the biggest one is not sort of planning out how your process is going to go and not having it covered. And I guess the last biggest one is not detailing your scope of work. You really want to be very careful about what's included and what's not included. And a really good way of making sure your client understands what's going to be an additional service or additional potential cost is making it clear that this was my scope and these listed things maybe are extra services. So that
That is
that
exactly how mine is done. That is exactly what I did. Like, I mean, the scope of work, that was actually my next question, is so important to be so specific so that there is A, nothing left out, but B, that there is no miscommunication to your point about what's included and what isn't. And so mine is itemized of every single thing we do in our process, which is labor intensive and you have to know your process. And if you're a new
Mhm.
designer, don't fret, it comes with time if you're listening. But I have everything that will be included. And then the next page is the exact same items, and I can remove whatever was included
Mhm.
in the page prior that is included in scope. And I'm left with, we also can do these additional services for additional fees. And then everything else is listed that we, so there is zero miscommunication on what is included in the price and what I will charge extra for if asked. And I
Yeah, that
like
that
that.
makes me actually really happy to hear because that's
Yeah,
perfect.
right.
Exactly how you should go about it. Yeah.
And when you do scope of work in your contracts that you have done, they do you I do like, again, I'm not sure if it's might have been done like this for years, but I do like a paragraph descriptor of all of the things, then the itemized list. Do you recommend that, or do you recommend just the itemized list?
No, a paragraph is great. So the scope of work document, which is something that would either be attached to your contract or maybe at the beginning of your contract, people have it done differently where they have their proposal, which becomes their scope of work, and then they have terms and conditions attached to that and everything gets signed off on. So in whatever configuration you do it, the scope of work section is really more the business section, and it's for really the designer to be as creative as they want, to be as detailed as they want. Of course, I'd say the more detailed, the better. But those are really your business terms, not so much your legal terms. And that's why I like keeping them separate because your contract will be basically something that doesn't really change unless your client says, hey, this this provision here, maybe we'll negotiate it. I don't know if I'm okay with that. But normally those terms won't change. Your scope of work might change depending on the project. So I include in my templates, the master service agreement template, uh, a standard sort of scope of work that kind of goes through all the different phases. But it's really up to the client how they want. I'm sorry, the designer how they want to scope it out, and everyone does their stages or their phases a little different.
Fair.
So there isn't one standard way of doing it. If yours looks different than another designer's, that's okay.
Yeah. Well, mine used to be like a 4-page, just all writing. It was, very utilitarian. It was just, Times New Roman. I printed it up. I had it match all of our client facing documents just to make it also not so dry. Like, it was really like a struggle to get through. Like, I figured no one's reading it. So now, I used to read it to the client, but we would be there for an hour, read it back and forth. And they
Yeah.
all look at me like, I am not a child. I can read. But you kind of want to make sure they understand everything. And I don't do that anymore. I take the onus of that they're willing to sign it, just like an app, right? Except if they don't want to read it,
Yeah.
that's not
I mean,
my,
they have a copy, they can go back later. But
yeah,
yeah, this is you can make it cute if you want. You can have
yeah.
graphics, bullet points,
Add your
add
photos in there,
personality to it.
whatever.
Yeah.
So my
Yeah.
next, and this is kind of not something that I was just thinking when you said like you added on the back end the terms and like when you are working, let's say I'm working with a traditional couple, let's say. So there's a woman and a man who live in a house together, and I have written both their names on the contract, but only one comes back and has signed it. Do you push back and say
Mhm.
make sure both sign it because both people are you're engaging with, or is one signature okay? Let's face it, running your own interior design business can feel overwhelming. But guess what? You don't have to do it alone. I am so excited to introduce a brand new way to get the support you need. One-on-one mentorship with me, Laura Thornton, your interior design bestie. In just one focused hour, we'll dive into whatever you need most, whether that's pricing strategies, client management, presentations, attracting clients, building up a repeat business, or just getting out of the hamster wheel. You'll get clarity, strategy, and expert advice based on my 28 years of running a thriving business and over the last decade, a 7-figure design firm. This is your chance to get real answers to the questions you've been dying to ask from someone who's actually been there and is currently still walking the walk. Book your session as you need it. There are no strings attached. You'll walk away with personalized, actionable advice that you can implement right away. One-on-one, 1-hour sessions as you need it. Head to the website or click the link in the show notes to book your mentorship session, and let's build a beautiful, profitable business that you've been dreaming of together.
Well, if this is a couple, they both own the home, essentially, uh, one signature is going to be fine because as a married couple, generally you bind your spouse to these legal arrangements. Um, but what I would say is in your contract, have designated a point of contact or the decision maker so that when you make decisions based on what wife told you, and then husband's like, wait, I didn't sign up on that. You can always go back to your contract and say, well, we all agreed, or it was agreed with me that this decision maker, because if both people need to make the decisions, then they should both be, designated the decision maker, and you need to sign up on both things. It really depends. I've heard of that being an issue with certain couples, where they're not really agreeing. So at least you might want to have the heads up where you get confirmation that both parties know this person is the decision maker.
Okay.
And it's not so much a legal thing, more of like, let's avoid issues down the line
Well, that's
thing.
kind of where I've pushed back a couple of times and said, "Can you please both sign it and send it back to me?" And eventually, I get it back again. But I also don't start engaging in any work until I have that contract, which I also think is a paramount thing. I know people say, "Oh, they'll send it to me," and we got going. And I'm like, I don't do anything until I've got that signed and the deposit check, and then we get rolling. But I
I
know that.
would absolutely agree with that 100%.
So I have had for the last 10 years a contract with my vendors. And every time I talk about this, people are shocked by it. So just like I have a contract with my clients, I have contracts with every vendor that I bring into any spaces that we're doing to ensure that they have the insurance that they are required to have to work with us, that they know what their parameters of what's expected on that job site, down to everything from picking up your own garbage and removing it out of the space. Is that a normal thing to have, or am I the only person in the world that has this contract?
I
Nobody seems to know
actually
about it.
I actually sell vendor contract templates
Right.
because I agree that they should be in place. I think
Right.
those relationships are so critical, and this is where the ball can drop. It's in these relationships, and if it's understood by other parties, or at least the designer and the vendor between themselves, that hey, if something happens, you got to pick up the ball. You're on the hook for this. I don't want to be on the hook for this. I'm
Mm.
bringing you into this deal. You're getting paid for it, and I need you to make sure that your insurance is going to cover any potential liability arising from you or your workers, etc. And so I think it's a really important contract to have, but I also agree a lot of people don't use them.
I know.
They don't even think that they need
Yeah,
to.
yeah. It was my lawyer who actually said we should do this, and I had never heard of it. But in hindsight, now that I'm doing this podcast and talking to people all the time, no one ever has heard of it. And I'm grateful that I've had it. Thank God I've knock on wood, I've never needed to use it. But it is one of those things where I too think it's important. You're protecting your client and yourself, right? So I,
100%.
yeah. So what other
And that,
contracts then are important for designers to have? So we've got your master service agreement, your vendor contract. Is there anything else that even I don't know? Oh,
I
there.
mean, yeah, absolutely. There
Okay.
are, when you think about your personnel, your employees, you should probably always have some sort of contract that reminds them about certain things like intellectual property. Hey, you designed this, but if you did it
Belong.
for
Yeah.
business,
Yeah.
um, you can't just take this home with you and use it, without our permission. Likewise, with any sort of other personnel that you bring in that is an employee, like an independent contractor, let's say you have a marketing person that's doing your social media, you want to have a contract with them, include
Mhm.
these things where you might want to say you have some warranties, some representation and warranties on their part that they're not going to, violate other people's IP when they post content, that they're going to follow those rules and have integrity, etc. Sorts of things that protect. In the end, these are all business protection sort of documents. If you sell e-design services online, you want to have your e-design contract, which is a little different because the way you obtain consent might be a little different. Payment might be just upfront. There's a lot of other intellectual property concerns you want to list out. There might be affiliate disclosures you want to make. So that's another type of contract that's popular. And similarly, your website terms and conditions, if you have a website, and privacy policy, um, an NDA.
Mhm.
Sometimes a designer will be asked to propose a design, a concept, or come in to see a place and it's, maybe a high profile client, they want to make sure everything's kept private. You might have an NDA that you sign at the beginning before you've actually been engaged when you're just doing sort of the business development of that particular project. So yeah, those are a few things.
Yeah.
I mean, you could think of like photography consent, release agreements when people are going to show up in your photographs. Um, yeah, those are. Oh, partnership agreements. If you're gonna go into business with a partner, you want to figure out roles and
Yes.
responsibilities,
Right.
payment, stuff like profit sharing. Yeah.
I mean, the employee one is really important. I mean, we have a binder. It's not just a contract, it's a binder this thick that they have to read and then
Mhm.
sign off on. And everything, like you said, like the intellectual property, but also how they represent themselves when they go to industry events. Like there is no alcohol consumption allowed. There isn't, well, because cannabis is legal in Ontario now. So that's all they sign off that they are not going to be doing that because they're
Mhm.
representing my company when they're on these job sites and on these parties and events that seem like they should be very fun, but they're a work industry event and you're representing our company. So we have a standard that we make them sign all of this.
Yeah, that's great.
Yeah,
Actually, I have several contracts on the site, but I always have these lists of new ones I want to put on, and one of them is an employee handbook, which
that's what we did. Yeah.
every company's quite different, but there's a few things like you just listed that would be quite common in this industry for employees.
Yeah.
So that's on my list of things to produce.
Yeah. And that's what we did. And yeah, there's a few things in there that, once in a while I just remind everybody when we're doing something, just a reminder, like, because again, it's my company that they're representing. And I get that everybody probably can handle a drink or two and they're not, bad people. It's just you want to make sure that they're reminded of what the rules and regulations are, or even outfits, clothing, how you're dressing, what you're showing up wearing on job sites. You can't be showing up in sandals. You need to be wearing a closed toe hard shoe, like just basic stuff. But it's important that it's written somewhere and signed off on because God forbid anything ever happens, you want to be protected. But I also really liked the independent employee contractor contract because I've hired many people and never had it. And so I never thought about it. So I'm glad you brought that one up too.
Yeah, that one I find particularly important when it comes to, let's say you hire some creative freelancers, some designers, some people that are going to produce sketches. Um, when it comes to an employee, under the law generally, the work that they produce, if they are actual employees, are considered work for hire. So even if you didn't have a contract, you would still have that sort of legal principle to fall back on. But with independent contractors, you need to make sure that they've signed everything off to you. So you need to have that language that said the work I'm doing is considered a work for hire under as defined in the Copyright Act. I assign everything to such and such firm, so that there isn't any question about whether these creative pieces of work can be used in another context or for another employer.
This is really important to any designer or decorator who's listening who hires out any of their AutoCAD drawings, their renderings, like anything that is like I know a lot of people hire out people to do those things for them, that this is a contract you should be having, or those designs are not yours. They can reuse
Exactly.
those in multiple places, or they can use those on their social media sites or on their, like those are things that's a good one because I know a lot of designers
Mhm.
didn't don't do their own AutoCAD drawings. Well, that is the basis of your design. So those are really important
Absolutely.
points.
That's your intellectual property. That's
Yes.
valuable stuff. Yeah.
Yeah. Can we touch on the intellectual property? Because I know, we do a lot of projects here where we do the full design and we always hope and pray they go with us to do all of the implementation, but sometimes they don't. And now they own that design. And that's part of this beauty. They own that design. But what does that mean then? Like I always feel like that's that they paid for it. It's theirs. They can run with it. They can hire other people to do it. So can we dive a little deep into the intellectual property and what exactly are, are we protected from with that contract with our client?
Okay. Well, there are ways to go about this. So in for example, my NDA template, the mutual either or whether it's mutual or just one-sided by the designer, it says I'm showing you these concepts or these works or documents, etc., proposals for consideration of a project only. If you want to proceed with this project, you will have to use us or have our permission.
Mm,
So this is probably a case where maybe they haven't paid for it. This is just like spec work, or even if they have paid for it, you can choose to do that. Whether the client is ultimately going to agree is a different story. You might have to negotiate these things, but generally, if they've paid for it and it's just concepts, you can't really protect ideas. So it's a great thing that they actually paid for it because at least you got paid for the work. Um, you can't um, really make anyone use you unless you've had them agree to it, right? And still there could be, issues. Not everyone pays attention to what their contracts say. But so when although you can't really protect ideas, you can protect the actual documents. So if they're actually using the documents without your permission, that is a copyright violation. If sketches are copied in any way, that's a copyright violation. So it really depends on, are they using your ideas or are they actually using your actual work product.
Right. So that's a great point too. You just brought up the copyright and trademark. How,
Mm-hmm.
I mean, is that just automatically covered because it's coming from our umbrella of our name, or do we actually have to go separately and have copyright and trademarking done?
Okay. Well, yes, let's take them this
Yeah, I was
take
just,
them when it comes to copyright, yes, you generally automatically have copyright protection the moment a work is published, is put out in the world. You've put it on paper, you've shown it to someone, you posted it online, you have copyright protection. However, if you wanted to enforce your copyrights, you would want a copyright registration because that's where all the laws are based off of. You want the federal laws to apply, you want to ask for damages, you want to ask for attorney's fees, and so you would want a registration to be able to sue and enforce your copyrights. Um, so it's always a good idea to have a registration, but it's not required in order to make a claim because you do get automatic protection. And when it comes to trademarks, so copyright will protect your works of authorship. Trademark is a little different in that trademark protects your brand, your logo, your name, your business name, what you use to basically market and sell your products or your services. So that would be a trademark. And yes, as long as you are using your trademark in commerce, you will have some level of protection in terms of like your locality. We call that common law trademark rights. But again, as with copyright, in order to fully enforce your rights, and let's say sue someone in another state for infringing, or someone using your trademarks online, like you will want a trademark registration so that you can enforce your rights under federal law.
so interesting. Okay. So I know that was off topic because it's still a contract, but you had mentioned it and I was like, oh, that's so interesting that it's just, it can be in there and covered partially. So,
Yeah, I actually do both. I on my ID Law Shop site, I sell contract templates and also provide IP services. So your copyright and trademark registrations.
okay, see, that's good to know too. Okay, so so basically we're making sure everybody who's listening has a contract before you start any project. We have to make sure that the scope of work is included and very clear. We need to make sure what's not included is also in your contract and very clear. And all the particulars of I have even down to lawn signs and photography in mine. Like
That's
it's
great.
very
Yeah,
thorough so that there's no question if you throw up a lawn sign that they signed off that you could. Um, and we've talked about the common pitfalls, but we know they both have to sign if possible. At least one is the good one. Is there anything else that, like, I also put in mind about payments, the payment terms, when it is, when it's due, how it's due, and if I don't have that payment by X dates, we shut the site down or we are no like so design I get paid in full before I've even started. So I don't have terms at all. But when it comes to implementation, there's setups and there's terms that should also be in your contract somewhere.
absolutely. Yeah, it needs to be very clear how you intend to be compensated, which this isn't part of what you asked, but it's related. You want to be very clear about what you're charging for, how you're charging. If you're going to be charging hourly, the clients should know you're going to be, this is what is considered in my hourly services. You want to have you want to give your clients itemized invoices to the extent you can. The more information, the better to justify the work you're doing, because this is where disputes come up, where clients might be surprised that something costs this much, or that you went to the site that many times, etc. So the best way to protect yourself is to just be as transparent and open as possible. And this also applies to discounts, to vendor discounts that you pass along. You want to, I know this is controversial and it's trending towards more disclosure than it had in the past, but there are even rules, like the ethical rules, like American Society of Interior Designers ethical rules, or for instance, Florida actual statutes that talk about you need to disclose how you are going to be compensated to your clients. Every state might have different laws, but generally, the idea is if you are making money off the back end, you should let your client know. Because this is also where designers get into trouble. Like
I
if
was
you look
gonna
at
say, you know what I
PayPal,
struggle with this? It's like
yeah.
it's just like are they anomaly? No one asks the contractor how they make money. Nobody, like, and this is off topic, but on topic, but off on a tangent. Nobody turns to
Yeah.
the contractor and says, okay, you charge me to build and you charge me this time. But I mean, they make money on every nail, piece of drywall, the base part. Like they make money all the way along, but nobody asks them to prove it, show it. I really struggle with how this industry is. I mean, I'm a Canadian, so thankfully we don't have the same laws as what you just mentioned in Florida. But it really
Mm.
irks me because nobody asks any other industry to disclose to this extent
Yes,
how
and I've heard
they
this
make money.
argument a lot.
Yeah, sorry.
Yeah.
Spoils my
Um,
for a Tuesday morning, first thing. But I know
I
that's
think
nothing to do with you. It's just really annoying to me that that's the case, especially since we're so heavily a female-based industry. It really bothers me. But if you do flat rate, do you negate all of that?
yeah, no, if you do a flat rate and it includes all the furnishings and your client says okay, I think you're in a better position.
Right.
But when you're doing cost plus and you're saying, this item costs $3,000 and making this much off of the discount that I'm also passing along to you. What designers have gotten in trouble is where the actual thing didn't cost $3,000, it cost 500, but they jacked up the price so they could make more off uh
And
the
what
percent.
what's wrong with that?
Okay. Well, because it's what the issue that arises is disclosures, like we're not being transparent. Um, if you're telling your client it costs retail $3,000, but it actually costs $5,000, you're actually making a misrepresentation. So what you should do is say, this costs $5,000, but I'm going to charge you whatever it is that you actually want to charge them so that they actually know.
Yeah, I know that's not your issue, but I am struggling very hard with this because that's that is the bread and butter of most interior designers' business is the furniture and the finishes. It is not design that's going to, this is why again, this is not your issue, but I'm really struggling. So this actually just takes us to, I mean, I always talk about changing over to flat rate and how that changed my business colossally. And it feels like this is another plus to doing so because you don't need to disclose anything. It's all flat rate. I don't tell my
Mhm,
clients how I charge. I don't break down where they're paying for what. I do not share my discounts. That's also in my contract. I don't share discounts on anything.
mhm,
I don't buy a
mhm,
lot of retail. That's the other thing. But if I'm able to buy from wholesale, that's a benefit to me and my company. And then there's
mhm,
suggested retail marketing prices. And if I charge
mhm.
in around there or just under, that should be a benefit to my client. But I don't think they should have any right to know how much I paid for that product. Now I get that that's just me and my biased opinion, and yeah, I don't feel like
That's
that's
what you're saying as well. And it just really depends on the representation you're making. If you're saying, I'm reselling this to you, that's a little bit different than saying, I've got this for you. I'm making the transaction for you, and I'm making money off this transaction based on this discount. And you're giving them a misleading price.
oh,
So
I'm
it's
sorry
a
that I
little bit
misunderstood
different.
you. Okay, so you're saying they're buying something in retail for whatever price and now saying it actually costs 3,000 as opposed to they
Right,
can
right.
find
The
that price.
issue
Oh,
is
I'm
where,
sorry. Okay, I misunderstood you. Yeah, okay. Yeah, yeah. So
yeah,
that's just bold-faced lying. I understand the difference now. So
yeah,
sorry. Goodbye.
and this has happened, and designers have gotten in trouble
Yes.
basically for lying.
Got it.
And I
Okay. So
think it's
that, okay.
because
So we're on two different, I'm
there's so
sorry,
much.
everyone listening. I didn't follow. That's my fault. Yeah.
It's okay, it's okay.
Sorry,
Yeah,
Erica.
it's interesting that there would be any sort of misunderstanding or confusion around it because it is gray. It's a bit of a gray area where there isn't a one standard way of doing it. Designers do it quite differently.
True.
So I just caution, do whatever you want to do, just don't
Protect yourself.
be misleading to your
Yeah,
clients about it.
that's fair. That's fair. Yeah, I mean, I don't disclose how I make money or how I what I upcharge. I don't feel like that's anyone's business, but I mean, that is our business model. We do a lot of custom and there isn't a price tag on custom. I could charge whatever I want. I feel like I'm very fairly priced. But yes, there is markup in there. 100% there is.
And
That's
I think most clients get that. They understand, they expect that there's going to be some markup for
yeah.
sure.
Like I always
So
say, I
that
don't
that,
go into a retail store when I'm buying jeans and say, well, how much did you buy these for in wherever the tag says it's made, right? Like it's just not the way that
Mhm.
anywhere. But our business is so funny that people feel like they can ask or that they do ask. And I don't know what it is about this industry or who did us a horrible disservice decades ago, but somebody did. And I mean, they're long gone, but really like did us all a horrible disservice. So, okay, so that's a pitfall. So you have to be careful how you word things or where you're buying from. And if you are buying retail and then marking it up, you can't do that. I mean, I'm going to imagine your quality is going to not be there either if you're buying for 500 and selling for 3,000, but full disclosure on where you're buying and what you're doing if that's your scenario because you can get sued or come back and get bit.
it just yes, you people mark up and you can mark up. Like I said, you just want to make sure you're not being misleading when it comes to that compensation structure.
And that kind of rolls into what I was just talking about quality. Let's talk about warranties and where that plays a role. I know I've
Mhm.
put the warranties into my contract. Is that something that's covered in yours as well?
I put warranty disclaimers in my contract.
Yeah,
So generally, we're not warranting anything.
yeah,
Um,
that's
you
exactly what
can have,
mine says.
okay, yeah, that if that's what you
Like,
mean,
I
yes,
mean, if it is a
exactly.
retail item, it's whatever you get from that retail store. But
Exactly.
otherwise, the warrant, yeah, you do not have a warranty with me at Thornton Design.
Exactly. So, and even mine goes on to say something like, even if we recommended this vendor, party, seller to you, we still do not guarantee their work or their quality. If you have an issue, you're going to have to rely on their respective refund or warranty policies.
This is a loaded question, which you might not know the answer to. And I'm really thankful I've never had to use my contract and to support my work or prove anything. But if you did go into a court of law with your contract, I mean, obviously there's already a cost of going there how the benefits I'm going to assume are a plus here. Like, how often does the contract actually make it that you walk away free and clear without any fault or fee?
Well, it's going to depend on what the issue is.
Fair.
I'll talk about a recent case that I was reading about where the designer sued the client because the client didn't want to pay because the client had issues with some of the workmanship and tried to pin all of the work on the designer. But because the contract had said, and everyone that relating to this project and understood, the designer was just there as basically a liaison. She was just managing the services. So yes, she was paying the GC, she was paying the vendors out from uh, on behalf of the owner. She wasn't taking on any of the responsibility. And what saved her was that the contract had said that. That contract said, I'm your agent, essentially, when it comes to the project management. And she won.
Great.
But for that contract, it would have been really gray and she would have had a difficult battle proving that she wasn't in sort of more of a direct role in implementing the design.
Mhm.
So just having that clarity was really helpful. So yeah, it always depends on what the issue is. If you have a client who doesn't want to pay, but your contract says you're responsible and your scope of work was XYZ, and you can show that you did XYZ, and you're gonna have the client's gonna have a really hard time showing why they're justified to not paying. Or if your contract says if there's a breach and you want client wants to get out of the contract because there's a breach, but the contract says, well, you need to tell me what the breach is, and you need to give me 7 days to cure that breach. And then if I can't cure it, then we can terminate this contract. If the client skips all of that, they have an issue, and
Mhm.
you're probably going to still be entitled to what's due.
Right. It's very interesting. You had mentioned earlier that, Florida had some issue, like, had some different legalities in other states. I know this might be more US based. And again, I'm Canadian, but my contract was made for Ontario on Canada and my process. What if you're crossing over into, like you were mentioning, Florida has some other legalese. What if I cross over into a different state or a different province? How does that, should I be tweaking my contract to accommodate the geographical location
Mhm.
lines, international state laws, or I specified a place in Bahamas. I never thought about, I just got them to sign my contract. And until that moment when you just talked about Florida, I had never thought about how that's going to read in Bahamas.
Mm-hmm. It will, I think it depends. So when you're doing stuff in another state or in another country, of course you should always see what might be applicable to you. And the gold standard would be have someone on the ground in that particular state that can review your agreement or be your advocate. Well, one way of maybe hedging your bets or protecting you outside of having a lawyer look at it is making sure in your dispute resolution section of your contract, in your governing law section of your contract, it says this contract is governed by Ontario law. Any disputes the venue for any dispute will be in such and such place. That is your local venue. So that's one way of dealing with that.
Okay.
But y- obviously, if you're constructing, getting into um, things that implicate local regulations, you should definitely
Mhm.
be understanding what those are and what consequences might befall you. Yeah.
Okay, so you've got a series of preset templates that cover all the things you mentioned earlier, which is quite extensive. And if I was using one of your templates, could I reach out to you to add a paragraph about going over state lines, or is something we just add in, or is that something that, um, like, maybe we can talk about your templates and what is covered?
So my templates all come with a bunch of marginalias. So there are all these notes that say, hey, in this section, you're going to have to fill out a blank. Here are some ideas or notes for
Oh,
how to do
cool.
that. Here, this section, it might implicate local law. You might want to have your local attorney review this to make sure. And in the insurance, when we're talking about insurance, I want
Mm,
you to call your insurance provider to make sure that this provision right here, this indemnification, for example, provision, is in line with your insurance coverage, and you're not promising more than you should be promising, or something like
yeah,
that.
I like that.
Um,
Okay.
yeah, there's some sections where it's tax specific. Make sure this is okay in your locality, that you're going to the reference to tax is accurate.
Ah, the other good one. Okay. Yeah, see, I could talk to you all day. So let's let's we're gonna the last thing I want to ask you is, if you had to pick one thing to tell any designer, whether they're seasoned or new with a contract, what is the one thing that they should include in their contract to safeguard their business?
Oh gosh, one thing to safeguard their business. I'm I'm big on IP. I really am. Maybe some people skip over this, and maybe it's not that important to them, but I really like protecting your intellectual property. I really like making sure that you have a provision in there that says, I provide you a license to use my design documents so long as you paid all that is due under this contract. This these design documents, and it could go on, these design documents are meant for design intent only. They're not meant for use in construction. Any unauthorized use of these documents is prohibited, and something that along the lines of, if you do use them, you release us from all liability of, wrongful use. So
Yeah.
the use of the design documents to me is a big deal. Other attorneys might have other ones that they think is more of a big deal, but coming from an IP background, I tend to highlight that.
So not only do we have that in our contract, just for anyone else listening as well, I also have that on every drawing template. It's in our, like, I know this is something that you probably don't know, but our drawing templates, I have notes on the side, and that is in its own box, completely separate, that this is for presentation purposes only, because technically they are to scale. And you could walk away and use those to build. And if we're not on that job site to manage it, I'm not taking responsibility. So all of it is a release that's pasted from the
Perfect.
contract onto our template. So if someone else is listening who hasn't done that, do that there too, to just double down and protect yourself. So Erica, where can everybody find you and find the templates? Like, where should they be following you on social media and or your website to be able to purchase these or take a look at them if they want to?
Hi, yeah. My website is ID Law Shop, www.idlawshop.com. And all the templates are on there, and more information on how to find me. There's some free stuff on tips for drafting your own contracts. A really cool checklist is on there. I have a blog with more tips and tricks for how to navigate some of these topics that we've talked about. And yeah, other than that, on LinkedIn as well.
Well, thank you so much for spending time with me today. Because like I said, I could have talked to you all day, but I know you're a busy lady who has to get back to work. So thank you very much for sharing all your
Thanks so
knowledge. I
much.
really appreciate it.
Yeah, I enjoyed it. Anytime.